Good morning, everyone. Welcome to the second day of the October docket for the Tennessee Court of Criminal Appeals. Let me introduce the panel again for those of you who were not here yesterday. To my left is Judge John Campbell from the Western Division, Germantown, Tennessee. To my right is Judge Robert Wiedemeyer from the Middle Division, Franklin, Tennessee, Judge? Franklin? Yes. And my name is Camille McMullen, and I too am from the Western Division, Memphis, Tennessee. The way this works is each side gets 20 minutes. If you, as the appellant, wish to reserve rebuttal time, please let us know at the top of your argument so we can help you keep up with that. Madam Clerk, do we have any preliminary matters?
No, Your Honor.
Okay, let's call the first case.
State of Tennessee versus Zyqiius, Quade, Barnes.
Good morning, Your Honors. Ben Russ of the Nashville Bar. I represent Mr. Barnes. It's nice to see you all again today.
Good to see you, Mr. Russ.
I would like to reserve 3 minutes of rebuttal time, please. I'm aware that the court has probably reviewed the briefs, but because some of the factual issues are pretty important to the issue that I want to argue this morning, I wanted to set the scene a little bit. Mr. Barnes had a sister named Miss Solomon. Her mother, who was also a witness, is named Miss Solomon, but I'm only referring to the sister in my argument, so just to clarify matters. Miss Solomon had a boyfriend, Mr. Campbell, who is the decedent in this matter. Mr. Barnes and Miss Solomon share the same father, who apparently on December 25th of 2018 was on his deathbed in Georgia. They had planned to go down together to visit him while they still had some time left with him, and they had gathered at the residence where Miss Solomon lived. In order to do that, I guess being the holidays as well as the fact that their father was near death, the situation was very tense. The two of them were arguing about various issues. And for some kind of way, it came about that Mr. Barnes wanted Miss Solomon to do something that she didn't want to do, so he took her car keys from her. As he got her keys, she's a little unclear how it happened. He either bumped her, pushed her, she fell to the ground. And he had her keys and refused to give them back. Mr. Campbell, the boyfriend, was present for this entire situation, and he then felt the need to interject himself between Mr. Barnes and Miss Solomon. And the testimony is a little unclear, but it appears that he took Mr. Barnes, who was approximately 1.5 feet shorter than him. They were in the kitchen of the residence, and pushed him up and kind of arm-barred him somewhere between his upper chest and his neck up against the countertops, the way I understand it from the record. Miss Solomon was physically in between them, not facing Mr. Barnes, trying to separate the two of them. Mr. Barnes later testified that it was around his neck. As I said, this disputed as to whether he was being choked or not, but he testified that he felt that he was in a serious danger of serious injury, that Mr. Campbell was insisting that he give the keys back, that he wasn't going to let him go unless he got the keys back, and he didn't know what was going to happen. So he drew his firearm and he shot 3 times. Actually, I think he shot 4 times. I don't recall whether one of the bullets that struck Miss Solomon was also fired and hit Mr. Campbell and then proceeded through him. But regardless, Mr. Campbell was killed in that incident. The issue that I wanted to talk about was the erroneous jury instruction that the state requested, a special instruction that the trial court then granted their request and gave regarding defense of a third person. As to Mr. Campbell's conduct, as I just said, he apparently felt the need to protect or at least intervene on Miss Solomon's behalf during this dispute. Miss Solomon described this interaction as a brother-sister fight. Her testimony did not make it seem as if she was in fear of being harmed by Mr. Barnes, and that it was serious enough, but not serious in a physical way, that she felt like this was going to continue. Furthermore, he had her keys, and she was trying to get them back. It wasn't a wrestling match or some sort of fight between the two of them. But Mr. Campbell intervened nonetheless, and then what happened after that. The instruction, which I've quoted in full in the brief that the state requested that the trial court gave, stated that the jury, in evaluating Mr. Campbell's conduct, that the acts of the deceased are not unlawful if they were done in defense of Solomon, and that Mr. Campbell would be justified in using force against Mr. Barnes. This instruction is clearly erroneous. Defenses are for the defendant. There is clear case law going back as far as the 90s that says you should not or cannot give jury instructions that are talking about defenses that they do not pertain to the defendant. The state doesn't even seriously argue in their brief that this isn't an erroneous instruction. They simply say that it's harmless error. I cited the Grant case in my brief, which the court probably will recall. It is relatively recent and very similar as far as the issue that's presented here. And the determination there was this was an erroneous instruction. The Grant court determined that in that instance it was harmless. I do not think it's harmless, and I'll certainly tell you why I think that. First of all, I think factually the Grant court is substantially different. In this situation, the instruction says that Mr. Campbell's is justified in protecting Miss Solomon, but at that point, what is he protecting her from? Mr. Barnes has her keys, and she's demanding that she give them back. I mean, the physical interaction, if that can even be called a fight in the physical sense, has ended already. Mr. Campbell was simply angry because his girlfriend got knocked over, which is certainly understandable, but I don't think factually it even rises to the level of defense of another party. Secondarily, or well, in my opinion, primarily, but a second point that I would make is when the judge gives an instruction, and the judge did give the self-defense instruction as well, and I skipped over that point, but Mr. Barnes' primary defense here is that he was in fear of serious injury and then he took lethal force, and that was justified. The court did give that instruction, but then simultaneously giving the instruction that I just quoted part of, saying that Mr. Campbell is justified in using force against Mr. Barnes, muddies the waters beyond repair here. It creates the air that's non-harmless. The jury is left to try to dissect, well, if Mr. Campbell believes sincerely that he is helping Ms. Solomon, is he justified in using the force that then is also the force that Mr. Barnes is using to perceive that he's in danger of being seriously harmed? That's hard for me to say, and I've done this before. And juries are left with that. And again, the instruction is erroneous. I mean, again, we're at harmlessness in my opinion.
Mr. Russ,
yes.
I'm not going to interrupt you a lot today, but the facts that, just remind me.
Yes.
The victim in this case, the one who died.
Yes.
There was proof in this case that he had basically retreated. He and the surviving victim, the sister,
Yes.
had retreated from the altercation.
I don't think that's 100% correct, Your Honor. Again, it's a little bit murky. That's not what Mr. Barnes, for example, said. Ms. Solomon said that she had her back to him.
Well, Ms. Solomon was the sister. And
Yeah, that
she
survived, yes.
was shot in the rear.
She was, yes, that's correct.
And the victim was shot too. Well, the proof was not as clear where the bullet path was.
Correct, yes.
But she had intervened in the
Yes.
altercation and had pushed the deceased victim, who obviously died, and she pushed him away, and they were leaving the home. Is that not what I read?
I mean, again, I think that's disputed as to, when you say leaving, I don't know, or rather I wouldn't, I think the proof is not clear as to whether the altercation had been terminated or was in the process of being terminated or not.
Well, didn't the deceased was shot 3 times in the back, right?
I believe the medical examiner said once in the arm and twice in the back, yes. And so, again, you know, I was here yesterday and contemplating, you know, there was a case that there were 7 shots fired, and I know the court hears these cases all the time. However, I think people like us who don't get involved in shootings fail to sometimes appreciate how quickly something like that can happen. He could have fired 3 shots in less than a second. And obviously...
And I really appreciate that aspect of your argument for the volume of shots. But in terms of where the shots landed, that is altogether another thing.
It is, Your Honor, and I understand. And again, in close proximity, I mean, I don't think this is a situation where he said, fine, keep the keys, made it to the table, and was shot in the back 3 times. I don't think that's what the proof shows. Was he standing as close as me to the microphone? I don't know the answer to that question. It's murky. Mr. Barnes maintains that he was still in a reasonable fear of his life. I don't know if Mr. Campbell was turning. I don't know if Miss Solomon was struck first with the first bullet, if she's in between them, and then Mr. Campbell turns as that happens. It isn't very clear from the record from either Mr. Barnes, Mr. Solomon, Miss Solomon, or the court reporter, the forensic pathologist, as to how that went down. And that's my point. I understand the court is aware about the volume of shots. And
Well, let me ask you this. Where does your client say that he felt that he was, there was the risk of serious death or bodily injury? Because it seems, and again, I haven't read the whole record yet, but it seemed to me from what he was saying is that he just didn't want to get stuck at the house. He wanted the keys and didn't want to get stuck there. It wasn't that he was afraid that he was going to get killed by Mr. Campbell.
I don't know that he was afraid he was going to be killed. I don't think there's anything in the record that says that Mr. Campbell was armed. But I do think he felt there was a serious physical mismatch, that he was substantially larger than him.
But he didn't really talk about that.
It was mentioned at some point. Again, I don't have the page number. He said that he was rushed and that he felt he was pinned around his neck. He felt that Mr. Campbell was not going to release him unless he gave Miss Solomon the keys back, and that caused him to fear that he would be further harmed. I don't have the word for word. I mean, again, and I guess this kind of jumps to my conclusion. What the state is asking this court to do is to stand in the shoes of the jury and say, no jury would have believed this self-defense argument. My argument is that's the jury's decision to make if it's correctly instructed. This court quite frequently says they're not going to stand in the shoes of the jury. If the jury doesn't hear this confusing argument, and another argument that I was going to make, which I'll insert here, by saying that if Mr. Campbell is justified in using force to protect his sister, that means that Mr. Barnes is now left to try to disprove that this instruction impermissibly shifts the burden over to him to show that he was acting in self-defense and that Mr. Campbell's actions were not justified. Of course, the court knows it's always the state's responsibility to prove, once it's properly raised, that Mr. Barnes was not acting in self-defense beyond a reasonable doubt. And so, again, I don't personally think it's a debate as to whether this instruction was correct or not. I understand the state's argument, but I would ask this court not to consider this harmless for that reason. If the trial court has properly instructed the jury, then it's up to the jury whether they believe Mr. Barnes's self-defense argument. I can tell that y'all are skeptical of his self-defense argument, but again, as this court has said numerous times to me and to others, this is not the place of the court to put themselves in the jury's shoes. I understand the harmlessness doctrine, but I do think if the trial court, had not instructed as it did, then the jury is free to determine, well, that doesn't make a whole lot of sense how an unarmed man gets shot twice in the back. Or he's an inch and a half or a foot and a half taller and he's got me by the neck and I don't know what's going to happen next. It's up to the jury. The jury did not believe it clearly because he was found guilty even of a lesser charge. So as it stood, I think that the prejudice there speaks for itself. The jury disregarded or did not believe his self-defense argument, and I think this erroneous instruction contributed to it significantly. So again, I don't think simply saying nobody would have believed that argument, I don't really think that's what we're here to do. I think it's here, was there error, and did it undermine the jury's verdict? And I think that it definitely would have, because again, it's shifting the burden and it's muddying the waters to the point that it's very difficult even for professionals to understand, well, if he's justified, but he could also be justified, so then does he have to show he wasn't justified, and he shouldn't have to show anything? Anyway, unless there's any other questions, I'll just reserve the balance of my time.
Thank you, Mr. Russ. Mr. Ball, General Ball.
Good morning, Your Honors. May it please the court. I'm obviously not Will Lundy. Mr. Lundy, unfortunately, has lost his voice and is unable to speak. And I think that it's probably a great tragedy for this court because while I have reviewed the record in this, I certainly don't have the knowledge of this case that Mr. Lundy would, but I'm happy to answer.
We understand, and we appreciate you standing in his stead.
Well, thank you. Thank you.
You're a utility player, and we're always happy to see you get in the game, and you do a great job. And now that I've complimented you, let me ask you to start out with this. So, some folks are on this jury, and they understand that this defendant is saying, I acted in self-defense because I was afraid of some force that was going to be used against me by this guy who's now deceased, unfortunately. And they're instructed by the judge about self-defense. And somewhere in there, they're also instructed if the guy who's now deceased, if he was using some force himself to protect this other person, then that's okay. That force is okay. Well, and that's the same force that the defendant is saying, hey, I was afraid that he was going to use force on me. And that's why it's self-defense, because it was reasonable for me to think this force was coming at me to hurt me seriously. Maybe not kill me, but seriously bodily injury. So how is it not, even if there's not a real good self-defense case, apparently it was fairly raised by the evidence, they were instructed. I'm just trying to figure out, it seems like a jury could get pretty confused by this, because they're saying, all right, the state has to prove beyond a reasonable doubt that this defendant did not act in self-defense. The defendant's saying, I did act in self-defense because this guy was going to use force against me, it hurt me. And then the judge tells them, well, if that guy was using force to protect this other lady, he's justified to do so. So doesn't that kind of create a muddy, as the lawyer just said, doesn't that kind of muddy the waters a little bit? And maybe it's harmless error, I don't know, but it seems pretty muddy to me.
I understand the concern there. Under these facts, and these specific facts, I think the issue of Mr. Campbell's use of force is really a red herring here, because the evidence here shows pretty indisputably that the victims were shot in the back after some sort of cessation of hostilities.
Well, I think I kind of agree with Judge Wiedemeyer's assessment of the confusion here. If it was so clear, Mr. Ball, why did we need that instruction?
We probably didn't need that instruction.
Okay. Is the state willing to concede that it was error? I know you kind of sort of do, y'all never do. But you do sort of, there's a way that you address these issues as, your friend on the other side says, it kind of lets us know in a way that this probably should not have been
Like
done.
less than half a paragraph. But if it was error, and then you start talking about what you really want to say, that's what I see there.
So a little inside baseball on this one. This was the first question I asked to Mr. Lundy when we had a moot court on this, so I certainly understand the court's concern
Well, I
here.
started the baseball stuff, so utility player, so fire away.
So I think that the state's approach to whether this was error was based more on the question of, I think the contours of this error are a little difficult to decipher given the case law on this. Belzer is helpful, but it's a pure self-defense instruction case. And then Grant, while being on point, the issue was waived there, and it was ultimately found to be harmless, so it's really dicta. But I do think that Belzer's general statement that defenses are for defendants is applicable here. So I think it's just really the simplest way to resolve this is to say this was harmless error, because it was harmless error. And I want to be clear about, certainly the defendant sort of got to the bar of raising a harmless error, but his own statements also make it, and the physical evidence here, make it impossible for any jury to return a verdict based on self-defense. Because, as I mentioned, The victims were shot in the back. Mr. Campbell was shot twice in the back and once in the arm, in the back of the arm. The defendant's sister was shot in the buttock. These were people moving away from the defendant, and notably, the defendant never said in his own testimony that he feared serious bodily injury or death. What he said was he feared being stuck. He talks about that, I believe, it was volume 5, page 345 of the record. Admittedly, my experience with the record here is limited, but I did not encounter him sort of saying that what he feared was serious injury or death, because what we're talking about here is not a violent fight. He is being restrained. He's being restrained by Mr. Campbell. The testimony was he grabbed him by his collar and he pushes him up and says, leave my sister alone, essentially. He's not punching him. He doesn't have his hands wrapped around his neck. Even in the defendant's version of this, he's restrained. He never says, I thought I was going to choke to death. I thought I was going to lose consciousness. What he says is, I thought I'd be stuck. And I take that to mean, Judge Campbell, you mentioned the car keys. I believe these were the sister's car keys. He had taken them to prevent her from leaving because she wasn't going to take this trip to Georgia with them to see their ailing father. I think what he's saying was, I was scared I'd be stuck in the kitchen, if I understand that correctly. My ingress and egress from the kitchen was blocked. And that certainly doesn't justify shooting someone 3 times in the back. So any reasonable juror here would reject this self-defense claim. And regardless of the propriety of this instruction on defense of another, it's really a red herring here because it doesn't matter how the jury resolved it. It doesn't matter what they thought if Mr. Campbell was justified, because there's this cessation of contact between the two. There's no current fight going on, and the victims are fleeing. No reasonable juror would have found self-defense. I'm happy to answer any other questions this court has. If there are no further questions, I would ask this court to affirm the judgment of the trial court.
Thank you, Mr. Ball.
Thank you, Your Honors.
Mr. Russ?
Yes, just briefly, a couple of points, Your Honors. And again, to Judge Campbell's point before, which General Ball just discussed, again, I don't recall every word of Mr. Barnes' testimony. I think that's accurate, what he had said. I don't think he said the magic words, so to speak. But on the other hand, it was apparently proof sufficient to raise the defense for the trial court to then give it.
The court charged self-defense.
Right.
Now, but again, we have case law in Tennessee that talks in terms of force versus deadly force. Force, you can use force to resist force. You can't use deadly force just to resist force. It has to be something that is, can lead to death or serious bodily injury. And was there any testimony that what Mr. Campbell was doing, especially for Mr. Barnes, because I didn't see anything, that he was truly in fear of serious bodily injury or death?
Again, I don't know that he said the magic words that I felt like he was going to kill me, or I felt like he was going to choke me to unconsciousness. I do think there's testimony both from Ms. Solomon and Mr. Barnes that he felt he was not really choking, but an arm bar around his neck, felt uncomfortable to the point that he was going to be harmed. I also think that being stuck, I felt like that testimony could be, well, one, I think it can be taken in multiple ways, because I took it to mean he felt like he was going to be stuck in this situation with someone who was a lot bigger who was attacking him. Not necessarily, he's going to get the keys from me and I'm not going to be able to get to Georgia. But that is not it wasn't particularly clear from his testimony what he did or didn't mean. So, yes, I will agree that Mr. Barnes, if I was coaching him on what to testify to, it would have been more clear. But I do think, A, the trial court felt it was sufficient to raise it, and B, your concerns are legitimate, but I feel that they're jury questions, Your Honor. I feel that if the jury thinks, as you apparently think, that they very well would have rejected it regardless of this instruction or not. But again, that's the jury's determination to make. I will point the court to Volume 4, 182, and about the next 10 to 12 pages is where Ms. Solomon's describing her recollection of what happened in the incident. And I don't know, again, that's my, from what I've briefed rather than the actual record, so of course would defer to the record. But the separation that seems to concern the de-escalation of this that may or may not have been going on. Clearly, in Mr. Barnes's mind, it wasn't going on. I don't think it's entirely clear. Yes, it could be taken that, as the general says, that they were walking out of the door, but I don't think that's exactly how the testimony came out. So I would just point the court to those particular issues. And lastly, I would say that, just to reiterate what I said before, that, and Judge Wiedemeyer's concern, how does this not confuse a jury? If some of the force was justified, but some of the other force was also justified, what as a juror are we supposed to do? I think the difference in what I'm saying is, if the state's attorney got up in closing and said, don't believe his self-defense argument, Mr. Campbell was acting to protect his girlfriend and he got killed for it. That's fine. You're arguing a factual issue. But when the court makes it a jury instruction, it elevates it to a matter of law, and that's the error. If the jury disbelieves because of the state's argument, that's totally fair game. But if they follow the judge's instruction as their reason, which was an erroneous instruction, then I think you have error that's non-harmless. Thank you.
Very well briefed, very well argued by both sides. The matter will be taken under advisement. Madam Clerk, please call the next case.
State of Tennessee versus Zyqiius Aurora.
May it please the court.